Good evening, everyone. My name is Professor John Dewar. I'm the Vice-Chancellor of La Trobe University. I'd like to begin by acknowledging the Wurundjeri people who are the traditional custodians of the land on which we meet this evening, and to pay my respects to their elders past and present of the Kulin Nation, and to extend that respect to other Indigenous Australians present this evening. It's also a real pleasure to acknowledge here this evening the presence of Professor Tong Shi-jun from the East China Normal University, who is leading a delegation of his colleagues to La Trobe for the next couple of days. East China Normal has been a partner of La Trobe's for nearly 30 years, one of the longest standing partnerships between an Australian and a Chinese university. And it's an absolute pleasure to welcome them here this evening as part of our 50th anniversary celebrations. What a pleasure it is to welcome so many of you to this wonderful building, to tonight's Bold Thinking event with Justice Michael Kirby. This is a very special edition of our Bold Thinking lecture series because it marks not just the university's 50th birthday this year, but also the anniversary of what we know at La Trobe as Archers, the Australian Research Centre in Sex, Health and Society, and the 25th anniversary of the La Trobe Law School. And when we were thinking about ways in which we could mark this triple celebration, a combined 100th birthday, if you like, we sat down to think about people who have a connection to La Trobe, who share our values, who have made an exceptional contribution to society, and whose work has crossed over disciplines that range from law to social research into sexuality, health, and human relationships. Well, who else could match Justice Kirby's experience and interest in all of these areas? His interest in human rights, his passion for supporting the interests of all members of the community, his belief in work that advances knowledge and promotes positive change in policy, practice, and in ordinary people's lives. It took us a very short period of time indeed to settle on Michael Kirby as the person we wanted to hear from to help us to celebrate these important milestones for the university. And we were absolutely thrilled when he accepted our invitation to take part. And what a wonderful space in which to have this event at the Great Hall of the NGV. We have a long-standing and very rich partnership with the NGV, but there's another nice connection between this hall and La Trobe. Those of you who visited our Bandura campus will be familiar with the wonderful Four Seasons stained glass panel by the late, great Leonard French, which is a much-loved feature of our campus. We need only look above us to see Leonard French's magnificent ceiling for this hall. Anyway, on to tonight's lecture. Before I introduce Justice Kirby, let me just say a few words about Archers and the law school, and about the La Trobe staff from whom we'll also be hearing tonight. Over the last 25 years, Archers has grown from a small centre that was originally funded by Vic Health to an internationally recognised research centre that has achieved the top rating of 5 in the last 2 federal government Excellence in Research for Australia assessments. It's not possible to do better than that. The centre focuses on social research on sexuality, health, and the social dimensions of human relationships. It's one of 4 national research centres in HIV/AIDS, blood-borne viruses, and sexually transmitted infections, and has made very significant research and policy contributions to women's sexual and reproductive health, men's health, LGBTI issues, sexuality education, and international sexual health. For 20 years of its 25-year existence, Professor Gary Dowsett, who sits immediately to the right, my right, of Justice Kirby, has been Deputy Director of Archers. He's a sociologist who has worked mainly in sexuality and HIV/AIDS research in Australia and abroad. including for the World Health Organization's Global Programme on AIDS. He is a member of the International Academy of Sex Research and a Fellow of the Academy of Social Sciences in Australia. And tonight he'll be following Justice Kirby's presentation by addressing a question on the intersection of sexuality, health and the law. How did we get to here? Over the last 25 years, the La Trobe Law School has grown to be one of the country's leading law schools, with a reputation for practical learning and a commitment to social justice and interdisciplinary inquiry and a spirit of service to the legal profession and the community. Under the leadership of Professor Patrick Kayser, who sits at the end there, the law school has advanced its focus on human rights and social justice. Patrick recently established a new partnership with the Asylum Seeker Resource Centre, and our students are working in a free legal clinic to help asylum seekers navigate the complex systems involved in applying for asylum. Patrick has also brought the Australian Lawyers for Human Rights Secretariat to La Trobe, and by nice coincidence, it was Justice Kirby who gave an inspiring speech at the event we held last year to celebrate this connection. Professor Anne-Maree Farrell, to Patrick's left, is the director of the Centre for Health, Law and Society in the La Trobe Law School, and she will also be talking tonight. Anne-Maree is an ARC Future Fellow and joined La Trobe just last year from Monash University and before that from the University of Manchester in the United Kingdom. Before she became an academic, Anne-Maree worked as a lawyer in private legal practice for 12 years in Australia and overseas, specialising in mass torts, product liability and medical negligence. Professor Farrell's research expertise lies in health law, policy and ethics. The head of our law school, the aforementioned Professor Patrick Kayser, will facilitate the question and answer session after each of our speakers has spoken. It's now my enormous pleasure to introduce Justice Michael Kirby. Michael has been associated with La Trobe for many years. In fact, his history with La Trobe goes back more than 25 years through both the law school and our Centre for Dialogue. He's also now, I'm pleased to say, a distinguished ambassador for Archers. In 2011, we awarded Justice Kirby an honorary degree, the Doctor of University, which is the highest honour La Trobe can confer on someone external to it, in recognition of his unwavering commitment to human rights, the rule of law, and social justice. Now, Justice Kirby's credentials are well known, so let me just summarise a few of the achievements from his outstanding career. He was inaugural chairman of the Australian Law Reform Commission, a judge of the Federal Court of Australia, president of the New South Wales Court of Appeal, and of course a judge of the High Court of Australia, for which he was twice acting Chief Justice. When he retired from the High Court in 2009, Justice Kirby was Australia's longest-serving judge. He was Chancellor of Macquarie University, President of the International Commission of Jurists in Geneva, and has served on numerous national and international bodies for organisations like the Human Rights Initiative, Council, the World Health Organization, the United Nations, and the World Bank. He's been Editor-in-Chief of the Laws of Australia, and he's been appointed Honorary Visiting Professor by no fewer than 12 universities. He participates regularly in many local and international conferences and meetings and has been awarded many honorary doctorates, including, as I've said, from La Trobe. In 2010, he was awarded the Gruber Justice Prize, and in 2014, he received the Leo Nevas Award for Human Rights from the United Nations Foundation of the United States of America. It is an absolute privilege that he joined us here this evening, and it's now my very great honour to introduce to you the Honourable Justice Michael Kirby.
Thank you very much for that over-fulsome introduction, Vice-Chancellor, and thank you for organising this event tonight in this most splendid hall of Australia, look up at the ceiling of Leonard French, the wonderful colour, the beautiful panels, the whole atmosphere is just wonderful. I've had the privilege of being here on a number of occasions, but there's no doubt we Sydney-siders have got to admit you've got it all over us so far as this wonderful venue is concerned, and beyond the venue, the wonders of art and the world of the spirit. Qui cherche trouve. That's the motto of La Trobe University. It's a motto in the French language, ancient French, and it means those who search will find. It's a good motto for a university because that is what a university should be about, searching and finding the truth and reason and science and rationality. With consciousness, rationality is the wonder of being alive. It's the wonder of being a human who is alive. And to have the privilege here tonight of having friends from the East China Normal University, other friends from overseas. I know that there are friends here from other universities who have come to join in La Trobe's celebration. And to all of us, fellow citizens, thank you for being here tonight. Qui cherche trouve. I was there not long after the establishment of La Trobe. At the time, I was an extremely troublesome student politician. There were a lot of us in those days. One of them was a young Gary Evans, president of the Melbourne SRC. I was president of the Sydney SRC. And we would have our August conference in Melbourne. And I came here in 1964, the year when the committee was established, on the initiative of Robert Menzies, who did wonderful things for education, and university education in particular, gave many of us opportunities we otherwise wouldn't have had. And at that time, the idea of the third university was established, but it was to be a university that was going to be a little bit different. It was going to look at things from a different angle. And so it did, including in my own discipline, the law. At first, it didn't establish a law school. It established a department of legal studies. And its purpose was to stand outside the law and to question things which the law basically didn't question. To question the way judges saw the law, or for that matter, the way Parliament saw the law, and to try to improve the law where that was justified, and to justify the improvements that were put forward. Qui cherche trouve. I thought it was a pretty good idea, and I knew the early people who were involved in the Department of Legal Studies, Professor Kingston Braybrook, and my own old teacher at the University of Sydney, Professor Tony Blackshield, who came down here to examine law from a realistic point of view, the legal realist's point of view, which had been taught in his department of the Sydney Law School by Professor Julia Stone, a great law teacher. And so in 1964, La Trobe began its journey. In 1967, Sir Henry Bolte, in the presence of Sir Robert Menzies, laid the foundation stone and urged that the university should be a university which would look at things slightly differently. And certainly the Australian Research Centre for Sex, Health and Society has looked at things in a different way and from a different angle and at a different subject, because in most of the country, back in 1964 or 67, nobody talked about these subjects. And rational examination of a matter so intimate and private as sex was really not appropriate in polite circles. And so La Trobe University began its journey, and its journey has included a wonderful law school and a wonderful research centre on sex, society and health. And I'm very proud to be here to help celebrate them all. The Vice-Chancellor claims a centenary. This is the way Vice-Chancellor, they're very clever with figures, you see. He puts the 50 for La Trobe plus the 25 for law and the 25 for the research centre and claims 100. But I don't mind. 100 it will be one day, but meantime at 50 it's quite an achievement, and it's a good occasion for us to get together and have a talk about something serious, which is what I'm going to now do. Back in 1969, I was obeying the rule that was then required in Australian society. I was obeying the rule of doing nothing about the urgent messages of sexual orientation that were coming to me. But Keys, Cherche, Trouve, in 1969 I found my partner Jan. He's up in Sydney tonight. I said, why don't you come down there? Melbourne people are really quite nice. But he said, no, you get on with it. I've heard all your speeches so many times. But we then observed the rule that when I telephoned him, I would let the phone ring twice and put it down and start again and ring again. And only then would he pick up the telephone. That was required because we were told by law and by religion and by society that we had to be thoroughly ashamed of ourselves and keep it all very secret and all to ourselves. But a terrible tragedy then befell us with the advent of the AIDS epidemic in the 1980s. I became involved in international committees. Jan became an Ankali, which is a kind of buddy looking after people who were living with AIDS in Sydney. And so suddenly health and law and our own lives seemed to take a bigger dimension, rather more important than the requirement of secrecy, and we began to be much more open about the realities, the truth, because if you search, you'll find the truth, and the truth will set you free. At that time, I began to be involved in work of United Nations committees. I went to Jamaica. Terrible things happen in Jamaica. Terrible things have happened quite recently in Jamaica. In the 1990s, a prison governor seeking to reduce the spread of HIV began to leave condoms in the prison and began also to leave bleach in the prison for the use of those who had needles and were using them in the prison compound. The prisoners didn't worry about the bleach, but they were very insulted by the condoms. That was suggesting that they were having sex with each other, which of course some were, and that was a terrible insult to them. And so they rioted, they objected, the prison governor locked the jail up and retreated, and the prisoners grasped those who they suspected to be gay, led them into a cell, bound them, and set on fire the bedding, and they burnt them to death to the screams of their fellow prisoners. They locked them in the cell and they burned them to death. You've got to really hate somebody to do a thing like that. And when more recently I went there to try to persuade for the United Nations Development Programme the government of Jamaica to get rid of the law that they had, which is still in force in most of the countries of the old British Empire and the Commonwealth of Nations, try to get rid of that law as the start to reaching out, respecting and protecting the people who were at the greatest risk. I was told of the case of Dwayne Jones. Dwayne Jones was a young person in Kingston, Jamaica, who was in a process of transitioning from male to female. And he made the terrible mistake for Kingston, Jamaica, to go to the local discotheque dressed in a dress. Dwayne Jones was immediately assaulted, he was stabbed, he was bludgeoned, he was knocked to the ground, he was kicked, and a car was ridden over him, and Dwayne Jones ultimately succumbed and died. You've got to really hate somebody to do so much to them. And his parents wouldn't claim his body. So ashamed were they of Dwayne. And so these are the images that come back to my mind when I'm asked to speak on the issue of the anniversary of the Centre for Sex, Health and Society. We don't now do things quite as bad as in Jamaica, but terrible things are still happening in our country and in the world. In the world, last week I was in Bangkok for a conference of the Asia Pacific Forum, looking at how on earth they can get rid of the laws in the Asia Pacific countries which still criminalise people who identify as gay, lesbian, bisexual or transgender. How can they change the laws? And at that meeting, one of the representatives from Bangladesh rose, and she said, "You've probably heard of the case in Dhaka of the two young gay men who were bold enough to begin setting up a newsletter for the community in Dhaka. They were given jobs in the American Embassy, to the credit of the American Embassy, in the hope of cloaking them with a degree of protection. But it didn't work. Last year, on Anzac Day, 2016, there was a knock on the door. Couriers. They opened the door, expecting to receive a courier for their newsletter, and 6 men rushed in and hacked them to death. And this leader of the community in Bangladesh read a statement that had been made by the LGBT community in Bangladesh. We're still hopeful to see that one day newspapers will be publishing the news of those murderers and terrorists who are responsible for killing our friends. Society will also be supporting, because our friends were just living human beings. Their families deserve justice for losing their sons so early in this inhuman way. We also hope that news media will be less brutal and judgmental. We can only hope society and surroundings of sulhas, and Tonoi family will be supportive and will not give them questionable looks every time they see them because their son was gay and was working for LGBT activism in Bangladesh. We always had and have faith in all religions and believe that religions are for peace in this world, and killing someone like this was never the intention of religion. And also at the Bangkok conference, we were told that just 2 days earlier in Maldives, a journalist who had been generous and supportive in reporting the conditions in Maldives for LGBT citizens, he was in his home and he was also hacked to death. This is just a week ago. This is not ancient history. This is what is happening in our world. And this is something that is intolerable. It's bad for health, it's bad for citizenship, it's bad for science, and it has to be changed. And are we perfect in Australia? No, we're not. In the last year, we had the proposal in respect of the marriage issue for LGBT people that there should be a plebiscite. A plebiscite was not put in position when the Aboriginal advancement was achieved. It was not put in position when advancement for the position of women in the law was achieved. It was not put in position when changes were made for disability discrimination, nor to get rid of the White Australia policy. But it was just saved up to put it in position as an obstacle that the LGBT community of this country had to jump. Well, fortunately, the Senate didn't approve of it. But the price of that has been that nothing has been done to follow up the rights of equality for LGBT citizens in this country, such as exist in 25 other countries with legal systems rather similar to our own. Now, this is not an issue that burns in my heart. I've been with my partner Jan for 48 years. 48 years of support, love and assistance. It's very good for your health. It's very good for your mental health. If you can find it, straight or gay, you're a very lucky human being. But it's denied in this country. And so the question is, why is this so? Why the murders in beautiful Jamaica? Why the murders in Dakar and in the Maldives and in other places? Why the feelings of injustice? I tried to work out in my brain this question, and it's the sort of question that the research centre can address itself to. Ask people, why are you being so cruel and nasty to people with just a little variation which you should just get over? It's part of nature. Well, the reasons that I've thought of are some people just have had limited experience. Well, that's getting a bit long in the tooth now because people have known about the issue for quite a while. Some people are just conservative. Well, that's okay. I'm a bit conservative on some things. But on the matter of basic rights of equality for citizens, there's a place for action where equality is denied. Some people are religious. I'm a bit religious. But I can't believe, and I agree with what the leaders in Bangladesh said, that religion, the true religion, is an enemy to people's health their lives, and their dignity as human beings. Some people say it's our culture. Well, the culture has to accept change. And culture, as Ban Ki-moon always said, what's your problem? The Universal Declaration of Human Rights says in Article 1, all persons are free and equal in dignity and rights. What's your problem with all persons? All persons includes LGBTI people. Maybe it's repulsion at the very thought. Some people say natural law stands against the equality of relationship recognition. Some say it's an aesthetic sense. They don't like the look of it. Some say that they just feel uncomfortable, personal demons. Well, get over it. Personal demons need to be adjusted to the fundamental principle of the equality of all Australian citizens, straight or gay. Qui cherche trouve. I think we must celebrate tonight the work of the Australian Centre for Sex, Health and Society, because it's trying to do something that the enemies of equality want to repress or prevent. It's trying to found our actions and our policies on sound data. In the earliest days of the AIDS epidemic, we resolved, and we followed it up in Australia, that we would found our policies and strategies on sound data, not on demons or myths or religious texts. We would do what the data suggested we should. And we reached out, we did brave and bold things, we provided needle exchange in pharmacies across our continental country, and the result is we have one of the lowest levels of HIV in the whole world, New Zealand and Australia, because we provided that measure out of love for other people. And this is what is needed in Bangladesh, in Maldives, and in Australia. The leader of the Human Rights Commission in Bangladesh asked me a question. How can we possibly get change in our country? And I said, when I was growing up, there was a similar hatred in Australia, and there was a lot of violence in Australia. But we got better. And how did you get better? We got better in the same way as earlier we got better on white Australia. We began to know Asian Australians. We began to know gay people. We began to know people of different race and different religion, and we began to get used to it, and even, eventually, to rather like it. When I was out at La Trobe today, I was really impressed that the campus is a microcosm of the variety of Australia today, which is so different from 1964 when I was still at university, and it's good. And it's good for Australia, it's good for our economy, and it's good for our universities and for the people in them. So, qui cherche trouve. I think that's a pretty good motto for a university, and it's a pretty good motto for this occasion. No more hatred, no more hostility, no more cruelty. It's against fundamental human rights, it's against people's right to health, it's against their mental health, and it's against equality of citizens in a country that should boast of equality. And to the extent that we are not achieving it in Australia, we must get to and change things. And to the extent that our neighbours and countries in the world are not achieving it, we Australians must be concerned about it and must lift our voices about it and must help them and must do research that helps them and must bring the research to the notice of our own people and help to change the world. It can be done, it will be done, but the speed at which it's being done starts here, and it depends on us.
Good evening, everyone. It's a pleasure to be here this evening and to represent Archers at this combined anniversaries Bold Thinking event. I want to start by taking a selective trip through the history of sexuality, health and the law, starting in 1905, to see how did we get to here, where we are today. And I think where we are today has been well described and discussed by Justice Kirby. 1905 saw the premiere of Richard Strauss's opera Salome in Dresden, based on the play by Oscar Wilde, notoriously imprisoned for gross indecency. Gustav Mahler wanted the premiere in Vienna, but it was banned there, and instead Vienna had to put up with the premiere of The Merry Widow. Austrians first saw Salome very soon after, and as Alex Ross notes in his book The Rest is Noise, it was performed before several crowned heads of Europe: Mahler, Arnold Schoenberg, Giacomo Puccini, Alban Berg, and the 17-year-old Adolf Hitler. Salome shocked audiences with its 15-year-old heroine performing the Dance of the Seven Veils and singing to a musical climax over the head of John the Baptist. Sexual desire had pushed romantic love off centre stage, and Strauss's score ensured that opera, indeed music, would never be the same again. It was in the midst of this artistic and cultural ferment that Sigmund Freud published his 3 essays on sexuality. The original 1905 essays, only recently translated into English, constituted a complete break with the existing medical theories on sexuality, including the startling conclusion that we are all originally polymorphously perverse. The first wireless broadcasts began in the USA that same year, and the first movie house was built in Pittsburgh. These would soon become the most powerful mass population influences on sexuality in the 20th century. Sexuality had begun its journey through what Ethel Spector Person termed the sexual century. Now, the most momentous event in Australia in 1905 was not related to sexuality. It was the first game played in the Australian Open. Nevertheless, the sexual century soon moved on, and we can see the threads that weave sexuality, health and the law together even more tightly. For example, during World War I, the new Australian government had to manage its quite frisky soldiers abroad by, for a time, deducting the pay from the 60,000 diggers diagnosed with a sexually transmissible infection. Much of this wage was paid to the wives at home, so this wasn't great public health policy in asking Australian women to be God's police, as Anne Summers termed them. Things changed quickly after the war as the Roaring Twenties saw skirts rise to the knee and Edwardian austerity end, best exemplified by the excesses of the flappers, a term used not only for women in Australia. In Europe, a new sexual freedom arose, particularly in the Weimar Republic, and best illustrated by the expressionists Otto Dix and Max Beckmann, and the novelists Christopher Isherwood and Thomas Mann. However, the Great Depression soon brought sexual repression, particularly in newly arisen totalitarian regimes. The Sexuality Research Centre and Library of Magnus Hirschfeld in Berlin was burned. Freud fled to the United Kingdom. Homosexual men were some of many who were imprisoned or interned, executed, or subjected to medical experiments by Nazi doctors. The eugenics underpinning these regimes saw sexuality, in the name of health and by using the law, become an arena for the exercise of power with a ferocity not seen in Europe since the Inquisition. The human sexual spirit, however, is not easily dampened, and whether we call it love, lust, or libido, This period also saw the rise of a globalising focus on sexuality in popular culture. Songs began to deal less with Edwardian's gathering lilacs in the spring again, and more with intimate love, such as in Cole Porter's Bewitched, Bothered and Bewildered. Mae West, in I'm No Angel in 1933, declared, "It's not the men in your life that matters, it's the life in your men." Sure enough, pin-ups of shirtless male stars, including our own Errol Flynn, began to feature in the industry's marketing tools. Betty Davis in Jezebel questioned virginity by wearing red to a ball where young unmarried women only ever wore white. Music theatre explored interracial relationships in Showboat in 1927 and again in South Pacific in 1949. All this engendered increased US government censorship, such as the Hays Code, demanding married couples only be depicted sleeping in separate beds on film and soon thereafter on television. The US government had good reason to be worried. When the male volume of the Kinsey Report was released in 1948, America was scandalised by the sexual activities of its citizens. The women's volume in 1953 was more circumspect, but still demonstrated a fluidity in women's sexual experiences that contradicted the prevailing medical and scientific view that human sexual interests were narrow or fixed. The Freud of 1905 was vindicated, while the rest of us wondered about ourselves and our neighbours. The Kinsey Institute continued its research, but mostly without US government funding, as conservative politicians mounted a sustained campaign against it in the era of McCarthyism and its obsession with homosexuality and communism. Without the assistance of the University of Indiana, the Institute would not have survived. And our understanding of human sexuality would be much poorer had those US politicians got their way. It was research such as this over the next 30 years that was to transform our understanding of human sexuality. In the 1960s, Masters and Johnson explored sex in laboratories and discovered where the female orgasm happened, exactly where Beverly Whipple found the G-spot 15 years later. Meanwhile, the pill arrived, largely solving the problem of premarital sex in one generation. Betty Davis was vindicated this time. In music theatre, Hair in 1967 ushered in a new era of public nudity and free love and confirmed rock music's enduring preoccupation with sex. It seemed like sexuality had become the heart of a rapidly changing social order. Meanwhile, two social movements were developing that transformed our sexual worlds, the women's liberation and the gay liberation movements. It is in their radical theories and practices that we find the antecedents of our current tortuous tango with sexuality. Many here lived through that period and actively contributed to those achievements, particularly in relation to women's sexual lives and the decriminalisation of homosexuality. It is also at this moment that the history of the sexual century changed dramatically as the locus of power and authority shifted in a new sexual politics. The universities were central to those achievements. La Trobe University, for example, hosted the 9th National Homosexual Rights Conference in 1983 here in Australia, during which delegates first discussed the AIDS and formed Australia's first AIDS-specific organisations. AIDS was soon to become central in global concerns about sexuality, health and the law, generating an intersection of forces very different from those which had controlled sexuality in the time of Freud. Indeed, the innovative Australian response to the early HIV epidemic here revealed that even we had moved on somewhat from our obsession with sport. Now, rather than explore that intersection of forces in Australia, instead I'm going to give a few examples from my experience in working with the World Health Organization to connect this sexual century to those global concerns and to some of the kinds of issues raised by Justice Kirby. In 2002, the World Health Organization convened a meeting in Geneva to revise its working definition of sexual health. An earlier meeting in 1975, which included members of the Kinsey Institute, medical researchers and sexologists, first defined sexual health as, among other things, something to, quote, enhance personality, communication and love, end quote. In 2002, a very different definition emerged, along with new definitions of sex, sexuality and sexual rights. It is a long definition, so I'll just mention the last sentence. Quote, For sexual health to be attained and maintained, the sexual rights of all persons must be respected, protected and fulfilled." End quote. This significant shift can partly be explained by examining the delegate list of the 2002 meeting. It included AIDS organisations, sex worker activists, gay men and sexuality researchers, most of whom were from the Global South, and women who had attended the International Conference on Population and Development in Cairo in 1996, where health politics shifted from human fertility to women's reproductive rights. Sexuality was clearly a new global ballgame. 10 years later, at another World Health Organization meeting, even more diverse delegates reviewed a report on sexual health, human rights and the law. Key issues this time included lessons from the HIV pandemic and its affected populations, the sexual rights of women, not just reproductive rights, legal equality for and the health needs of sexual minorities and gender diverse people, and the role of the law in achieving that. In these meetings and documents, and many like them, we can see the significant influence of the sexual century, particularly of sexuality research, second wave feminism, queer theory, cultural activism, and the HIV pandemic, in dramatically bringing about the quite different understandings of human sexuality in health and law now current in the 21st century. It is during this period that Arches began its research program and built its reputation. This is our tradition. Much changed during the sexual century, but as the current unconscionable delay on marriage equality in Australia indicates, the challenges of the sexual century are not over. There are more to come. And I'll now hand over to my colleague, Professor Anne-Maree Farrell. Thank you very much.
Thank you, Gary. First of all, I'd like to thank Justice Kirby for his fine speech and indeed his outstanding contribution to the law and public service in Australia as well as internationally. We are better for his erudite judicial reasoning in often quite difficult cases, including his well-known dissenting judgments, for surviving the vagaries of judicial and legal politics, and for being our longest-serving judicial officer. In particular, we should honour his groundbreaking work, as highlighted this evening, in health law and sexuality, and specifically in relation to HIV/AIDS, which has been crucial in providing an impetus for law reform in the area and has been underpinned by his strong commitment to human rights as both a moral and legal framework. While my colleague, Professor Gary Dowsett, has admirably reflected upon sexuality and its diverse expressions and identities to date, what I'd like to do in the time I have is to briefly explore how we might understand the relationship between law and health and how this might intersect with questions about sexuality and sexual health both now and in the future. So how should we view this relationship between law and health? I start from the premise that health includes both good and ill health at an individual and a population level. It should be understood as being influenced by social and cultural settings, as well as informed by science, medicine and technology, and law itself. Well, what about law? For most people who are not lawyers, it wouldn't be unusual to hear the law perhaps referred to in monolithic or all-encompassing terms. For example, people might refer to the law, the need to obey the law, of being subject to the rule of law. However, for law academics, judges, and legal practitioners, the law is a diverse and complex world, made up of the common law, judge-made law, legislation, regulation, legal institutions such as courts and tribunals, as well as what we might call softer forms that may not be legally binding, but which may nevertheless influence behaviour, such as norms, guidance, and procedures. So with this understanding of law in mind, I suggest that if we're to properly understand law's relationship with health, then we must not only consider law on the books, for example in legislation, but also how law works, or conversely does not work, in practice. This means that we must take account of the context in which this relationship takes place. Adopting this contextual approach requires that we understand how this relationship has been and continues to be influenced by historical, social and cultural understandings, including marginalisation of particular individuals and groups, as well as by broader political and economic dynamics. Taking these contexts into account means we must be prepared to challenge claims made about law's neutrality and seemingly benign power in the field of health. A better understanding of how people's lived experience of the law influences and how that influences whether and how they access and receive healthcare might not only engender our compassion, but also provide valuable insights into how the law should be reformed in pursuit of health equity and social justice. In pursuing this contextual approach to understanding law's relationship with health, academic staff working within La Trobe's Centre for Health, Law and Society, and indeed the law school more generally, are continuing with a long-established tradition of what is known as law in context or law in society research and critique, which has been at the heart of renowned legal scholarship and practice by La Trobe academics over many decades. It is a tradition that is worth celebrating as we reflect on the university's first 50 years, and long may it continue. So how might we consider this contextual approach in terms of what it means for viewing the relationship between health, law and sexualities? For present purposes, I'd like to separate out sexuality and sexual health. And as Professor Dowsett has already pointed out, we've all moved on from quite a narrow concept of an understanding of sexuality towards an acknowledgement that is a central aspect of being human throughout life, encompassing sex, gender identities and roles, sexual orientation, eroticism, pleasures, intimacy, and reproduction. Sexual health needs to be understood, as the WHO has pointed out, as a state of physical, emotional, mental and social well-being in relation to sexuality, rather than a state of physical, an absence of disease, dysfunction, infirmity. Indeed, there is much potential, and indeed, in some countries, a good deal of progress, which has already been made in using the law to promote acceptance of sexuality and sexual health as described in this way. Most notably, as Justice Kirby has pointed out in his work, through human rights legal frameworks, but also in other legal arenas such as anti-discrimination law, privacy and confidentiality, as well as health law and regulation more generally. However, in acknowledging such potential, we must also critically reflect upon the fact that the law has been, and indeed continues to be, as Justice Kirby has pointed out, used as a powerful mechanism of surveillance, marginalisation and punishment against individuals and groups who are perceived in certain societies to not conform to heterosexual norms and ways of living. As both Justice Kirby and Professor Dowsett have pointed out, the failure to embed marriage equality in law remains a blot on our national social and political life. Elsewhere, women who engage in same-sex relations are subject to criminal penalty in 43 countries, as are men who do likewise in 73 countries, with the death penalty being a sentencing option in 13 countries. In these jurisdictions, the criminal law operates as an unjust and repressive social control mechanism. And as Justice Kirby has pointed out in his work on the legal response to the HIV epidemic, it is a mechanism which has only served to undermine a range of positive public health initiatives in the field, with affected individuals being driven underground, unable or unwilling to be identified, diagnosed or receive much needed medical treatment. So in identifying the actual harm that can be caused by deploying law to control or repress sexual expression and its impact upon, and indeed adverse impact upon sexual health, it's also important to acknowledge, call me an optimist because I'm a lawyer, the positive role that law can potentially play in the area. This involves recognising as a matter of first principle that regardless of our sexual orientation or gender identity, we are all equal before the law and therefore entitled to the same privileges and protections under the law. At the very least, this should involve legal recognition of marriage equality in the Australian context. Going further, there should be a shift towards explicit legal recognition of sexual rights, including the right to sexual health. This would involve separating out sexual rights from reproductive rights. In the Australian context, these rights could be embedded in what is a long overdue move towards a national bill or charter of human rights. As the 21st century unfolds, it's also worth reflecting on the fact that how we express and experience our sexuality is increasingly being framed, organised and experienced through technology, such as the internet, social media, artificial intelligence and robotics. In the age of big data, ensuring legal compliance with privacy and security of health information, including information relating to our sexuality and sexual health, is becoming increasingly difficult. Law will need to be harnessed in both traditional and new ways to ensure that adequate protections are in place to guard against narrow, algorithmic conceptions of sexuality, as well as unwanted government and corporate intrusion into our sexual lives and sexual health. So, to conclude, I'd like to think that 100 years from now, Trobe University will be celebrating its 150th anniversary. In celebrating such a milestone, perhaps a similar event such as this one might be held one evening. At such an event, one might hope that the 21st century will be hailed as having consolidated and expanded upon the gains made in the 20th century, or what Professor Dowsett has described as the sexual century, where the right to express our diverse sexualities and gender identities as human beings had been fully accepted in social and legal terms, where the promotion of sexual health was embedded as a core and prioritised aspect of public health policy, and where our political leaders had fully accepted all necessary reforms to the law to both enable and protect sexuality and sexual health as part of building a just and equitable society. Thank you.
That was excellent.
Friends, it's my great pleasure to be the moderator for a question and answer session, which will commence shortly. Indeed, His Honour Justice Kirby categorically insisted that there had to be a public question and answer session this evening. So I'm going to start moderating it now. I understand there are workers with roving mics over here. So if you would like to ask a panel member a question, please raise your hand and yeah.
Yeah, sure. Good evening. My name's Michelle. I'm from Transgender Victoria, but I speak on my own behalf. Sorry, there's something. Is that? That's good. Yeah. I do speak on my own behalf, not on Transgender Victoria's behalf. The fight for marriage equality, indeed, it's been highlighted by several of the speakers this evening, and it's a worthy and worthy cause that needs to be addressed. One other cause that has been addressed that in the last year, but has failed to result in a positive outcome, has been the question of change of gender on birth certificates in this state. You know, I find, to my great surprise, that to change my gender on birth certificate to match my gender identity that I live in, I have to not only divorce my partner of some 40 years, but also have to undergo an invasive surgical procedure that will render me sterile. This seems to me to be equivalent to eugenics and a grave injustice. Can any of the panel suggest how we should go about getting that changed? Because the legislation, with the support of the Daniel Andrews Labor government in this state, went up before Parliament and failed by a single vote to get passed.
Well, this is something that has been debated in a number of countries. Several countries, as you know, have moved in Scandinavia, but also in Malta recently. Catholic Malta has moved to facilitate the change. And I was at a very interesting conference in Hong Kong. If you look at the laws throughout Asia, they all require the knife. They all require the knife. And all the states of Australia, I think, still require the knife. Certainly a number of them still require the knife. And at this conference, they did a very unusual thing. They invited a person to come who was not a lawyer or a social scientist. He was a doctor. He was a surgeon. He was from Belgium, and he did the transformation operations all the time. And basically, he was flat out fixing up the botched up jobs that had happened throughout the world that got to his knife. And he showed the photographs of the operations, as doctors tend to do at their conferences. And the photographs showed what an overwhelmingly radical surgery it is, and how quite often they can be botched up. And therefore, at the end of the conference, we, as a United Nations meeting, resolved to pass a resolution. And we did that because at that very time, by sheer coincidence, there was a bill in the Parliament and the Legislative Council of Hong Kong to require that to change the name on the identity card, which you can't get anywhere in Hong Kong without your identity card. You have to undergo the knife. And we sent a message to the Legislative Council on behalf of people from all over the world, and the doctor joined in. This is completely unreasonable. Kate McGregor, who was there, who is a prominent Australian and a transgender specialist, she said, "These are supposed to be our private parts. This is my private parts. Keep them private and mind your own business." And essentially that's what we told the legislators, and to their great credit, the bill in the Legislative Council of Hong Kong was defeated. We're still waiting for the new terms of the legislation, but there's something deep in the mentality of people in many countries. First of all, most countries won't allow any change, ever, any circumstances, but those that do tend to require the knife. And we've just got to get over it and say what people have under their skirt or under their trousers is their own business, and you should respect their dignity as people. If they want the knife, it's a very big operation, but if they have informed consent and they want it and they are competent to give that consent, fine. But it should not be a requirement. And that is the way the law is developing, and it's the way it should develop quickly.
Yeah, good day. My name's Andrew. This is a question to Michael Kirby. Firstly, thank you very much for your nod to marvellous Melbourne. I'm sure we're all Melbourne chauvinists, just as I am. It is a marvellous city, and it's great to have you here today. A mention was made in regards to whether a Bill of Rights might make a difference towards recognising the rights that are currently been denied us. I was wondering if you could speak to that with your knowledge of the Australian Constitution and perhaps briefly reflecting on your time as a High Court judge. Thank you.
Well, I grew up in the tradition of the English common law that you didn't need a Bill of Rights in an English-speaking country because Parliament would always fix everything up. Ultimately, it would fix things up. And then I got appointed to be the chairman of the Law Reform Commission for 10 years or 11 years, and I then learned Parliament doesn't fix it up. Unless it's sexy, unless it's vote-winning, unless it's interesting to the electors in their electorate, they are often, I respectfully say, just not interested. Sir Anthony Mason, in a very sharp article, said, anyone who believes that Parliament will fix things up believes in fairy stories. This is just not what happens in reality. And therefore, what you have to face up to is that sometimes there is a role in a free country and a democracy for the judges to do work that Parliament hasn't done. The common law has been doing that for centuries, and in the area of equality, that's something that we should entrust to the judges. The proposal, which is reflected in the Victorian Charter, is that Parliament gets the last say, and it can, having had the inconsistency with the Bill of Rights, the Charter of Rights, drawn to notice, if it decides not to do anything, then that's it. Parliament has the last say. But meantime, there is a room for another branch of government to stimulate action. I think this is something that should come throughout Australia. If I had a choice, if there was one thing I could do, I would wish that our federal constitution had a provision for equality. Not just for Aboriginal people, not just for women, not just for people on the grounds of race or skin colour, but on all grounds. Unless it is material, unless there's some reason for an inequality, the Constitution should preserve equality. That is so in most constitutions in the world now. There's an equality provision. And if I could just have one big change in our Constitution, I would want that. But it's opposed by both of the major parties, and I'm not expecting to see it too soon. My father lived to 96. I'm now quite a young man still, and I'm hoping to last for at least another 20 or 30 years, and I'm hoping that I will live to see a national Bill of Rights, or at least a national equality provision, so that unequal laws can be tested against that provision and, where appropriate, struck down by our courts. And we have had form on this in Australia. We've had so many examples of it, and it would be a good thing to have that protection.
Hi, Judge. Just on that question, I was just wondering, could a Bill of Rights introduction potentially lead to a rights clash where you have the freedom of speech going up against the right to be treated equally, with Section 18C of the Racial Discrimination Act coming to mind?
Well, I'm not going to get into the issue of 18C. Long experience has taught me to sort of concentrate on the issue that is before us, and the issue that's before us is very specific to the sensitive question, which has been neglected and that people don't tend to want to talk about, which is the role of sexuality. And I think that Gary's review of the literature and the development shows a lot has happened, but there's still a long way to go. Of course, free speech should be protected under the law. But there's no absolute free speech, and free speech has to have exceptions. Everyone accepts that. And the debate is about where the exceptions should be and what they should say, and I think that is a matter of detail. Much more fundamental is something that was raised at the conference in Bangkok, which I'll share with you, which I hadn't thought about, and I've thought a lot about these issues of sexuality. A number of the participants said, we LGBTIQA people have been putting up with this alphabet soup of LGBTQ for queer, I for intersex, A for allies, plus for anything else that we've missed out on. And effectively, this has been putting labels on people. And why are we accepting? We've already accepted so many injustices over the time. Why are we accepting labels when, in fact, people's sexuality is what it is? Some gay men are so-called straight acting, some are feminine, and that frightens some people. But it's simply a matter of insisting that in the matter of our sexual expression, it's so deeply hardwired into it and so deeply part of us, or it has developed over our life experience, that people have just got to get used to it and not insist that people fit into boxes. People have insisted in the past that you fit it into a box, a binary box. You're either a man or a woman, Adam and Eve, no Adam and Steve, and you've just got to fit into that box, and please do not challenge my mentality by not fitting into that box, one or the other. Well, it's LGBTIAQ plus, and there's lots of those boxes, and essentially it's trying to get at a point that Anne-Maree made, that people have just got to accept that this is a complicated matter. It's in our nature and in our experience, and if it's in our nature and in our DNA, as to some extent, to a large extent I think it is, then those who don't like that have just got to get over it, and they've got to be told, get over it, mind your own business, these are private parts, keep your mind on other things, on higher, ethereal, Leonard French type things, and leave people's sexuality to them.
Come on. Surely, this is an opportunity to...
Sorry, coming.
We got someone waving over there? One of our law students.
This is a worry.
Thank you. Thank you very much, everyone, for your speech. My name's Paul Kidd. I'm a student here at the law school. Justice Kirby, you've written about the sodomy laws as that populated the British Commonwealth or the British Empire as Britain's most unlovely legal export. And today, there, as somebody mentioned before, there are still 73 countries in the world where sodomy is illegal, and almost 2/3 of those are British Commonwealth countries. As we have been pushing back against those laws, there's been a new reaction which Dennis Altman has written about in particular, about the way in which that is seen as a new kind of paternalism or a new colonialism trying to enforce Western ideas on those countries. So my question is about how do we tread that fine line between pushing for what we know is right without being seen as paternalistic or colonial, and without encouraging a bigger pushback against trying to do the right thing, particularly given the urgency that is driven by the fact that the various examples that you gave of those terrible acts of violence that are happening every day around the world.
Well, first of all, I'm very glad you mentioned Dennis Altman, who is a great professor at Trobe University over many years, but before that, he was in student politics at the same time as I was. It's amazing, you know, how all those student troublemakers become members of the establishment in due course. And some of them remain committed to the liberal ideals of their youth. And Dennis has certainly done that and has been a wonderful expositor and interpreter of what is happening in the big world. And your question is an example of one of the issues he's raised. Now, I served about 10 years ago or 7 years ago on a Commonwealth committee. It was called the Eminent Persons Group, so naturally I was very happy about that title. And it was designed to look into the future of the Commonwealth. And the group was chaired by Tun Abdullah Badawi, a previous Prime Minister of Malaysia, and a considerable Islamic scholar and an Islamic believer. And it had another person from Pakistan who was Islamic, and we agreed unanimously on this committee to recommend to Commonwealth leaders that they get rid of the section which was common to every criminal code the British ever gave to every country where the Union Jack ever flew, including Ireland and the United States of America and Burma. They had this law against gay sex, and that was recommended, and it was recommended both for the importance of it in the AIDS epidemic, because the figures of the epidemic showed they were basically double the rate in Commonwealth countries which got that law when compared to countries of the former French Empire or the Netherlands Empire or the German Empire which hadn't had that law. And therefore, both for the reason of principle and for the reason of the AIDS epidemic, we recommend it. Well, that then went to the officials, and Sir Humphrey then got the last say, and that really put a logjam on it, and that logjam is still in place. And the progress is very slow. Once or twice, last year there was a big case in Belize in Latin America, and the Chief Justice struck it down under constitutional reasons of equality. And little changes happen here and there, but the logjam is still in place. And actually, a very good thing happened last year. The UN High Commission on Human Rights, Council on Human Rights, established an independent expert on so-called SOGI, sexual orientation, gender identity. And immediately that was passed, there was a move in the General Assembly to try and stop it. And that move was attempted in the fifth committee, which is about the third committee, which is about the politics, and it was defeated there, just defeated, and then it was taken to the plenary of the General Assembly and just defeated, and then they took it to the fifth committee, which is the Budget Committee, and it was just defeated, and then it was taken to the plenary of the General Assembly and just defeated. This was the African group, and they were supported by the International Islamic Conference and by the Holy See and a few other opponents, but it remains in place. Now, the question is this something we should just back off from because some people's culture or their religious beliefs finds it difficult? The answer to that is the answer that the former Secretary-General gave, Ban Ki-moon. What is your problem about every person having the right to equality and dignity? And therefore, as Ban Ki-moon's answer to your question was, people are entitled to their religion. People are entitled to their culture. They must be respected. But when they bump up against other people's rights to their fundamental human rights, then those human rights must be given effect if they relate to their dignity and rights. And recognising a person's sexual orientation, we've known this science now for 70 years. How long do you have to know the science to tell people, well, you've just got to go back to look at your holy text. You've just got to go back into your society and try to get them to understand the change. The scientists are researching and have been telling us this for 70 years, and going back and saying, well, this is your culture and this is your religion, and therefore other people have just got to suffer and put up with it and be deprived of a very important part of their lives, which is good for their health. That's just not on. And that is the message that the UN, fortunately, in all of those votes, adhered to. And I hope it always will, and it's a basic principle of universal human rights.
I think we have time for one more question. Over here, there's a hand waving.
Sorry, can't just get through. Oh, sorry.
Right up the back.
Do I have to stand up? Thank you. We heard a bit tonight about the crimes committed in
the Maldives and Jamaica and Dhaka recently, and you used the word hate. And I wondered, particularly in light of the controversial Safe Schools program that has had lots of criticism, whether it is hate or whether there are other factors that have been researched that allow humans to do those things to other humans. Thank you.
Well, that's a very good question, and it's relevant to the work I've been recently doing on North Korea for the United Nations Human Rights Council, and we are in a current state which is really quite dangerous, and you have to hope that there will not be hate, there will be rationality, proportionality, people will make the right decisions, because we have so many nuclear stockpiles that we don't need all those nuclear weapons to destroy everything. All the beauties of this world could be destroyed in an afternoon. So there is a danger in the existence of hate. It does exist in some hearts. I don't retreat from saying that I can't understand anybody that could go in to the home of a stranger and hack them to death. You would really have to have a really very strong feeling against them to do such a thing, as distinct from having an argument, maybe trying to read them a holy text or persuade them or something of that kind. But I think your question is actually quite a good one, and that is the sort of thing that the Australian Research Centre for Sex, Health and Society could be researching and trying to find out what leads people to. I mean, why do intelligent, educated senators, Senator Bernardi, whom I've met, who's a very intelligent man, I mean, why does he hate us? Why does he have this very strong antipathy? Why does he not respect the fact that science says there's just this relatively small proportion of his fellow citizens who have a different way of expressing their feelings of love and sexual feelings, and it's just part of the reality. Get over it, get used to it. But I think you've hit on a good point. Maybe I shouldn't label it as hate, though it does sound awfully like the case in the Maldives, the case in Bangladesh, and the case of Dwayne Jones and the prisoners in the cells and all the other cases we've heard of, and the young men pushed off the cliffs in Sydney. That does sound, a bit like hate. But maybe it's just they're misguided. Maybe they're misled. Maybe they're misled by their religious pastors. Well, we've all got to get together and try to get over this. Because it's not as if we don't know. We've known the science at least since Kinsey, and we've got this centre that's developing the science, and similarly the Burnett Centre in Melbourne, the Kirby Institute in Sydney is developing this knowledge all the time. And when you've got knowledge and science, it behoves our leaders, it behoves our senators, it behoves our representatives to inform them of the social science and the medical science, and to act accordingly. They did so once with the AIDS epidemic. They did it, and they saved thousands and thousands of Australian lives because they did it. Well, they've just got to get to doing it again, and it's got to become a habit of mind, rationality, and perhaps a restoration of a high degree of secularism in our society. People are entitled to their religion. I've still got my religion. I'm quite happy being an Anglican. The Anglicans at least are making a bit of an effort on this issue. But it's my business. It's a private thing. And I wouldn't dream of trying to force my religious views on other people. That was one of the good gifts the British gave us, the idea of the separation of religion and the state, and the idea of secularism, including in public schools. And I think these are very important values of Australia. We should defend them.
Friends, it's my very pleasant task to offer a vote of thanks to our panellists and Justice Michael Kirby this evening. I had the good fortune to spend a bit of time with the judge earlier today. He always chides me for calling him judge. He says he's not a judge anymore. Stop calling me judge, call me Michael, but I just can't do it. I have to call you judge. How do you start a conversation with a legend? It's a difficult thing to do. So I said, what are you doing after this gig? And he said something about going to some other university in Tasmania that we won't name. And then he said on Friday he's going to Japan to get an Order of the Rising Sun with the gold and silver star from the Emperor of Japan. Now, I asked him why he's receiving that award, and he told me that the UN Human Rights Council some years ago appointed him to engage in some very important diplomatic work, assisting diplomatic work with the North Korean government around the abductions by that government of Japanese people about 30 years ago. And for that he's receiving this high imperial honour in Japan on Sunday. It's impossible to keep up with how many amazing things this man does. It would keep a fleet of Wikipedia editors busy all the time. So I'm not going to try. I'm just going to ask you to join me in thanking our panellists, Professor Anne-Maree Farrell from our law school and the Centre for Health, Law and Society, Professor Gary Dowsett from the Centre for Sex, Health and Society, the Research Centre for Sex, Health and Society, and also Justice Kirby, in particular Justice Kirby, for your courage, your wisdom, and your humanity. It's an absolute pleasure spending time with you today and being involved in this evening's event. You're not just a national treasure, you're an international treasure. Thank you very much, Justice Kirby.
Thank you.
And thank you, Gary.
Okay, that's it.